that's not good. I don't that doesn't sound professional to me. You know, so how do you address that problem? I mean, that's
Well, again, Carmen, what we did in this report, which was unique from our other reports, is we took some of the Courtwatch's observations and we put those items in the report because we do think that the judges should be aware that people notice certain things like that. They notice that behavior and that it is disturbing to the public. I mean, we have to remember that these volunteers come from all walks of life. We have people who are retired, we have students, we have homemakers who come in and give us their time, and they're, as citizens of our community, are making an observation. And I, who wrote the report, made the decision that some of these things should be included in the report to make the court aware that, in fact, these are things that we see that are disturbing to the public. You'll also note that there were a lot of positive things that the court watchers say about the judges.
Right.
That some, the judges run their courtrooms efficiently, that some of them have really tight ships. What we want to do is we want to encourage them all to have really efficient courtrooms with really tight ships. That's our goal, is to make our system to comply with, best practices, which is get there on time, get these cases moved, and have the trials when everybody's ready. Clearly, one of our reporting factors is continuance rates. We realize that certain things happen. People get sick, witnesses can't make it to court, even judges get sick. But we're at a current rate of 50% of the time when you go to court on a given day on a matter, that matter is going to get continued. That's a difficult thing for the public to stomach. So we want to encourage more efficiency. Now, we now have a new allotment system that the DA and the defense bar have, touted as going to be really successful with helping us move cases, and that begins July 1st. And
you're talking about the vertical prosecution.
The vertical allotment.
Mm-hmm.
And we're hoping to see some change with that. Now, are we going to see immediate change on July 1st? No, because they're starting it on July 1st. But hopefully, for our July to December report, we'll notice more of, efficiency going on, where the cases are either better prepared, ready to go to court, the continuance rates drop, and we see that the goals that the two sides and the court are hoping to achieve actually are achieved.
Well, looking at your report, I mean, to make a broad summary of it, it seems like presently it looks like NOLA Courtwatch is pretty well pleased with the conduct of the attorneys and the prosecutors and the police and everybody except for the continuance issue. That seems to be your issue. In other words, it looks like all the judges, you say pretty nice things about them. The DAs are pretty highly rated. Even the attorneys don't get slammed too bad in this report. The witnesses are showing up, but you're saying the continuances seem to be, it's hard to explain why there's so many continuances.
Courtwatch NOLA's initial objective was to get these cases moving. And so the focus of this report and previous reports has been the continuance rate.
Okay.
And you'll see that, fortunately from 2008 into 2009, there's been a dramatic decrease in continuances. Not a good enough one. I mean, we're not where we need to be, but we're certainly better than where we were.
Gotcha.
And I do think that when the attorneys show up and they are prepared, but we're changing our data sheet as of July 1st, and we're going to start asking harder questions, because at this point we do need to have more information given to the public. We need to tell them more than just how many times the judges are late or how many cases got continued. So our goal is our next reporting will be more teeth to it.
right. And a lot of times, when you go to court, you don't know what's going to happen. You don't know what's going to go on. So, I mean, do you think it's the judge's responsibility to address all issues? Sometimes you're so nervous that the judge speaks to you and you don't know what to say or do. And they may, they ask you if you understand, and I guess most people agree, but they really don't know the legal system enough to really absorb everything that's happening at that moment. And then there's also, a tendency for, the judges and the prosecutors and defense attorneys, the judges at least, they pressure the attorneys to kind of either enter a plea or to try cases as opposed to continue them repeatedly so that they don't appear insufficient. But I mean, do you think that's the case? Do you think they're just trying to get through the day really fast and get home?
Let me address two of the questions that you had.
Okay.
The first question was, do I think that the judges explain things sufficiently? And number one, the judge's duty really is to be a neutral. So it's important when they ask a question that the person who they're asking the question to understands it. But the person who's supposed to be making sure that the witness, or if it's the defendant or the accused party, is aware of what's going on is really their attorney's responsibility. So the judges, as much as they need to make sure that the defendant, if they're pleading guilty, is entering into that freely and voluntarily, they're presuming that that information has been explained to them prior to the actual entering of the plea. With regard to the docket management, as much as it appears that the judges are placing pressure onto the parties to move the matter forward, that's their job. Ultimately, the judges are responsible for the docket management, and though you'll note that in many courts, the judges allow the attorneys to confer and do scheduling with their own calendars. But the reality of it is as you can see by our report, unfortunately, when it comes right down to it, the person who's going to be called on the carpet or be held accountable for whether or not a case moves forward is the judge. And so it is the judge's responsibility to place pressure and to move these cases forward. Because if the evidence is there and the prosecutor is prepared to prosecute it, the defense should be prepared to defend it, and we need to get these cases moved forward. I mean, it's twofold. It's not just for the victims, it's also for the accused persons. I mean, we have people that may be sitting in jail who have been accused improperly, that they're sitting there getting their case continued over and over and over again, just as much as that victim's not getting their case heard. So for the public in general, it's important that the cases move forward. And we are not an outcome-driven organization. We're not there to say, get this matter to trial, get somebody convicted. We don't keep statistics on whether or not somebody was convicted or what the sentencing was. Our goal is really just about efficiency in the criminal justice system. And as much as our report currently seems to focus on the judges, because the continuance rate ultimately falls to whether or not by each section, it is a system. And so you note that we do report on the defense attorneys, we do report on the prosecutors. You'll note that the prosecutors' request for continuances has decreased, that the defense attorneys have seemed to maintain themselves, and sometimes that's a tactic. Sometimes the defense wants to request a continuance because it's in their best interest for their defendant for delay. And that's why it's important for the judge not to allow a tactic on either side to take place, and that they do have to be the heavy at times to make that case go forward.
And if any of our listeners want to call in and ask questions or give your comments about whether you think cases are going too slowly through the system, or maybe people are being railroaded by the system, depending on your own experiences, you definitely can join in by giving us a call at 504-260-9265 here at WBOK and speak with our guests. Continuances are an interesting issue because, of course, I've encountered as a trial lawyer the situation, and I won't mention any names, but occasionally run into a judge. It's like the first time you go in front of him for the arraignment, he's like, okay, it's now or never. I'll give you a deal now, but I won't give you one later, because they feel like they need to get their case over with quickly. And so they hand you a big stack of papers and ask you to plead your client guilty before you've even had a chance to really read through what they've got. That certainly is not an appropriate way to run a credible system of justice. And on the other hand, cases I've had more than once the case, especially at Tulane and Broad, where my client is like, no, I didn't do this. I want to go to trial. I feel like I've got the evidence to go to trial. I feel like, we're going to prevail and this person's going to be able to put this behind him if we can just get our day in court. And maybe the charges are so serious